So please join me in welcoming Claudia. And I will say, while she makes her way here, please hold your questions. We will have some time for questions afterwards, unless you prefer it.
Today, I want to explore how a city can become a preferred arbitral seat. The competition is tough. Everywhere we turn, there's a flurry of new arbitral institutions or hearing centers or announcements of new arbitration laws. It's all part of a bigger effort to become the next global arbitration hub in what has become an epic battle of the seats. It can be as ferocious as Survivor or American Ninja Warrior, but with lawyers. And this battle has good reason. As always, follow the money. Arbitration contributes significantly to a city's economy in multiple ways. It generates work for legal counsel, expert witnesses, and providers of support services such as transcription, translation, and interpretation. Arbitration proceedings generate spending at hotels, transportation, restaurants, and retail. And arbitration indirectly raises the profile and reputation of the city, particularly with businesses internationally. Back in 2012, the first economic impact study of arbitration in Toronto estimated a $250 million boost to the local economy, according to Charles River Associates. And some commentators say the impact on New York City's economy from hosting international arbitration exceeds $1 billion. The benefits are real. So how does a city transform itself into more than just a safe seat, but also a preferred seat? First, a quick refresher on why the seat of an arbitration matters. And I'll use the term seat and place interchangeably. The seat is a legal concept referring to the jurisdiction in which the arbitration is deemed to take place, and it has important consequences. The seat determines the law governing an arbitration's procedure, which is referred to as the lex arbitri. An arbitration's procedure is mostly fixed by party agreement, including the agreement to use particular arbitral rules. But the lex arbitri can play an important gap-filling role in deciding procedural issues on which the parties have not reached agreement. Many jurisdictions impose mandatory requirements on arbitration seated within that jurisdiction, and those rules cannot be waived. Courts of the seat also have sole jurisdiction to hear applications to annul the award or set aside the award. Courts of other jurisdictions may refuse to enforce an award, but they don't have the authority to vacate the award. The seat, therefore, also determines the grounds on which awards can be annulled, because standards and procedures for challenging arbitral awards differ between jurisdictions. The seats can have significant impact on whether a challenge is successful. And that's not all. Arbitral tribunals and courts will usually determine the arbitrability of a dispute on the basis of the law of the seat. And what's more, the choice of seat determines which court has the power to grant interim relief, assist with the taking of evidence, and secure the participation of witnesses in the arbitration and the production of documents. In many arbitration cases, the seat and the physical place of an oral hearing are the same, but parties may designate one place as the seat and hold hearings in a different place for convenience. And feel free to come in, for sure. So let's next look at the concept of a preferred seat. The most recent Queen Mary study, released last week, found the top 5 preferred seats are London, Singapore, Hong Kong, Beijing, and Paris. But I don't believe this survey of preferences really tells us much about the most selected cities and why they are preferred. This brings to mind an altogether different kind of seat selection. The process my husband and I went through to buy chairs for our house. My husband has very long legs. So initially, we each had different seat preferences, but eventually we chose something that worked for both of us. Now, in the Queen Mary study, this set of preferences is more about what respondents might want, but not necessarily what would be selected in a negotiated process when parties are choosing a legal or neutral seat. At the ICC court, the top 5 seats in 2023 were Paris, London, Geneva, New York, and Singapore. The GAR 100 data report provides very interesting information about the seats actually selected in their GAR 100 submissions. Over the last 10 years, London has been the most popular seat, followed by Singapore, and then Paris, Hong Kong, and Dubai. The data also shows that international arbitration is indeed very international. The single most important seat selected is other, a catch-all term for about 300 seats in the data. Now, to consider how a city can become a preferred seat, it's important to distinguish between 3 types of arbitration. First, domestic arbitration, where all of the parties are from the same jurisdiction, and they have opted for arbitration as a dispute resolution mechanism rather than their own courts. Second, an international contract involving parties from different countries, but the arbitration is seated in the same country as one of the parties. This means that the parties have not chosen a neutral seat, but instead, one of the parties had the bargaining power to insist on arbitration seated in their country. We often see this in contracts involving states and state entities, which often insist on local governing law and a local seat. The law may in fact mandate this, or quite frankly, the state has the bargaining power. And the third category are international contracts, but the parties have selected a seat in a neutral location, and that is not the jurisdiction of either party. So if a city is striving to be in this third category, selected as a neutral seat, it doesn't need to be in categories 1 or 2. And it doesn't need a strong domestic arbitration culture or have the bargaining power to insist on arbitration in its own jurisdiction. So let me be very, very clear. A strong domestic arbitration culture is not a precondition for a city becoming a preferred arbitral hub. Look at Brazil. It has a strong domestic arbitration culture, but we do not see very many international arbitrations seated in Sao Paulo or other Brazilian cities that have nothing to do with Brazil. On the flip side, the most preferred arbitral hubs do not have a strong domestic arbitration culture. Arbitration is not typically used for purely domestic arbitration in the UK or France, and yet London and Paris are the most preferred arbitral seats in ICC arbitration, and they're among the top 5 seats overall in the Queen Mary study and other rankings. At the ICC court, we have many more cases seated in London than we have UK parties using ICC arbitration. This means that for the most part, when London is selected as a seat, none of the parties to the contract are from the UK. Here are some numbers to illustrate this point. In 2023, cities in France were selected as the place of arbitration in 99 cases, but there were only 69 French parties in ICC arbitration. So even if we assume that Paris was selected as a seat in all cases involving French parties, this means that Paris was selected as a seat in 30 cases in which there were no French parties involved. For the UK, the comparison is even starker. In 2023, London was selected as a seat in 85 cases, but there were only 47 UK parties. This is also the case for arbitration seated in more preferred seats involving New York, Geneva, or Zurich, and Singapore, cities in which neither party is from the seat, and because neither party is from the seat. For the rest of the world, the number of parties from any jurisdiction far exceeds the number of cases seated in that jurisdiction. Take Mexico. There were 111 Mexican parties in ICC arbitrations, but only 19 cases seated in Mexico. In Spain, we had 104 Spanish parties, but only 18 cases seated in Spanish cities. This means that most of the cases involving Mexican or Spanish parties were seated in their counterpart's jurisdiction because the party had the bargaining power, or the cases were seated in a neutral city where neither party had a connection. ICC arbitrations were seated in more than 100 cities, but the top 10, with London and Paris leading the pack, account for more than 60% of the cases. More than half of the cases at the ICC court in recent years were seated in the same jurisdiction as one of the parties, and I actually found this data quite surprising because we are always thinking about the seat as a neutral selection. For many places that have improved their arbitration ecosystem to a certain extent, foreign investors are more comfortable and therefore willing to accept arbitration seated in the same jurisdiction as their counterparty when dealing with a state or state entity. Yet very few cities are considered truly neutral seats, selected when there is no connection to any of the parties. So what makes a good seat? The latest Queen Mary study found that the factors influencing seat preference were consistent with those cited by respondents in previous surveys. These include the support for arbitration by local courts, neutrality and impartiality of the local legal system and national arbitration law, and a strong enforcement track record. In 2021, greater support for arbitration by local courts and the judiciary was the #1 adaptation that would make other arbitral seats more attractive. This was followed by neutrality and impartiality of the local legal system. Now, we have seen a variety of efforts aimed at identifying safe seats and have helped states amend their laws and develop the legal and logistical infrastructure that really matters. To mark the 100th anniversary in 2015, the Chartered Institute of Arbitrators designated 10 principles for an effective and efficient seat in international arbitration, focused on identifying the key characteristics that make a particular place an appropriate and effective location for international arbitration. These are known as the London Principles and require arbitration-friendly laws, efficient courts with limited court intervention, and logistical support and ethical standards. Then in 2018, the GAR CIARB Seat Index was created to help users identify safe and effective seats based on the CIARB London principles. The goal was to create a system in which the seats were judged on several key features and not simply popularity. 6 jurisdictions were selected: Hong Kong, London, New York, Paris, Singapore, and Switzerland, with Geneva and Zurich in the same category. And all of the jurisdictions adhered to the London principles with little meaningful distinction between them. Then Delos also created a list of so-called safe seats, which it described as places of arbitration where the legal framework and practice of the courts support recourse to arbitration as a fair, just, and cost-effective binding dispute resolution mechanism. A seat may be considered Delos safe, even if it does not have all of the hallmarks of today's most popular arbitration seats. Now, more than 40 cities are considered safe seats, and approximately a dozen more are emerging safe seats. However, they don't include a single city in Latin America outside of Brazil, and no city in Africa is named other than Port Louis in Mauritius. We don't have information to assess whether a determination has been made that the other cities not on the list are in fact not safe according to these criteria, or if these other jurisdictions have not yet been analyzed. What we do know is this: more than 170 countries have signed the New York Convention. More than 120 jurisdictions have adopted arbitration laws based on the UNCITRAL model law on international commercial arbitration. And yet, legal infrastructure is not enough. With respect to the safe seats, in fact, only Singapore incorporates the model law. The arbitration laws applicable in Switzerland, the UK, New York, and Paris have similar principles, but don't incorporate the model law. So what this suggests is that being recognized as a safe seat and a preferred seat requires more than adopting modern international arbitration legislation. And moving from being considered a safe seat to a selected neutral seat requires even more. At the end of last year, Karim Youssef coined the phrase international hub formation in an excellent speech he gave at Sharm el-Sheikh, discussing how to transform Middle Eastern and North African seats into global arbitration hubs. He rightly called this a complex process, arguing that arbitration hubs are not born, but made. And his key rules for aspiring hubs include the importance of being established business centers, surpassing the baseline of the New York Convention in its approach to enforcement, and developing an arbitration hub culture. So why is Singapore such a popular seat? Well, we can learn a lot from the rise of Singapore as both a regional and global arbitration hub in such a short period of time. Singapore benefits from its strategic global location at the crossroads of major economies and transportation routes, making it a convenient meeting point for parties from diverse jurisdictions. Yet geography is only one essential element. Singapore has taken a comprehensive and long-term approach to becoming an arbitration hub. It meticulously refined its legal ecosystem. International arbitration is part of its overall economic growth strategy with a stable legal environment and robust legal system. The Singapore courts are known for their steadfast support of international arbitration and their tendency for upholding the integrity of arbitration agreements made by the parties. The judiciary has consistently adopted pro-arbitration stance since the introduction of its Arbitration Act 30 years ago in 1994. The courts regularly uphold the enforceability of arbitral agreements and rarely set aside arbitral awards. So Singapore is the ultimate success story. What about the cities that have failed to make the grade? Well, I think there are 5 key reasons why some cities fall behind. The first is thinking, if you build it, they will come. We see initiatives everywhere to build hearing centers or open an arbitral institution with the hope that this would be enough for parties to select the city as a seat. This is underway in Chicago, although currently there's very little arbitration actively there. Other cities are doing the same, but without the appropriate legal infrastructure to support arbitration, the appeal of the city as a neutral seat will be limited. And there is a proliferation of arbitral institutions around the world, many with only a handful of cases. Careful planning and a comprehensive approach are needed to become an appealing neutral seat. A nicely decorated conference room or new arbitral institution is not enough. There needs to be a well-developed body of commercial law used widely in business contracts, adequate funding for the center to survive its initial years, and widespread legal, academic, and judicial support. The second cause of failure is short-term thinking. And I recall a conversation with a lawyer in Japan who said the country had failed in its effort to promote arbitration. And he had reached this conclusion because a hearing center in Japan had been open for only 2 years, but had few bookings. This kind of short-term thinking doesn't work with international arbitration. As the president of the ICC court, my job is a lot like the director of an arboretum. A director plants trees, but never sees the tree reach maturity. And in a similar way, what I see happening now in ICC arbitration was put in place by my predecessor and my predecessor's predecessor, who I know is here in the audience. Only about 20% of ICC cases arose from contracts signed in the last 2 years. And half of the cases arise from contracts signed in the last 5 to 10 years. This means that everything I've been speaking about reflects decisions about the seat of arbitration made many, many years ago. Singapore is one jurisdiction that has had a long-term comprehensive strategy, and we see how that careful planning is paying off. The third reason for failure is geography, or location, location, location. Sydney has learned the hard way that location is critical. The city tried to position itself as a preferred seat for Asia, and despite extensive marketing campaigns to attract arbitrators, it is just too far away. A direct flight from Delhi to Sydney is nearly 13 hours, but half the time to get to Singapore. A direct flight from Seoul to Sydney is more than 10 hours, but just 6 to Singapore. And what we see happening is that arbitration seated in Australia have at least one Australian party who has the bargaining power to insist on a city in Australia rather than a neutral seat. The fourth reason for failure is geography plus the lack of direct flights. Geopolitics is not the only factor inhibiting the chance of a city's success as a preferred seat, even when geography is on its side. Mauritius, for example, made a big push to be a preferred seat for African and Indian-related disputes. And with favored tax treaties, the island nation became a tax haven for companies investing in Africa and India. It would have seemed logical that Mauritius could then evolve into a trusted seat for Africa or India-related disputes. After all, it is the only so-called safe seat for international arbitration in the African continent, according to the Delos Guide. Mauritius, however, is a prime example of how the legal formalities are not enough. It turns out that there are very few direct flights to Mauritius from the African continent, and those flights are expensive. It's a beautiful island and a fabulous place to go for holiday, and as the crow flies, Mauritius is closer than London or Paris, but logistically, it's not at all convenient. The fifth source of failure is geopolitics. Even if a location is on your side, geopolitics can still get in the way. The Philippines is much closer to Hong Kong than Singapore, but Filipino parties now prefer Singapore because of geopolitics. By the same token, can we expect a diminished role of New York or other US seats in the near future? This might happen if travel to the United States becomes more difficult due to shifting visa requirements or uncertainty about entering the country, even if entry is completely authorized. Fewer international students may want to study in the United States, which could mean fewer international students obtaining LLMs and taking the New York bar, and therefore being familiar and comfortable with New York law. Time will tell. Related to geopolitics is regional stability. The Rwandan capital, Kigali, has made significant strides recently to become an arbitration center, and travel there is relatively easy. But if tensions between Rwanda and the Democratic Republic of Congo escalate, parties may start looking elsewhere for a reliable and secure seat. Now, geography isn't the only reason why certain cities have failed to take off as preferred seats. Preferences have been shifting due to new capital flows. At the ICC court, as I mentioned, Paris and London remain number 1 and number 2. But they are getting a smaller slice of the pie. In other words, the percentage of cases overall that select Paris or London has declined over the last 10 years as Singapore and other cities have emerged as viable alternatives. So while capital previously flowed primarily west to east and north to south, today we see an increase in interregional agreements within Asia. And with this change, parties in Asia and the Middle East have greater bargaining power. Nearly 60% of Asia's trade is now conducted with regional trade partners, up from 53% in 2000, and it's expected to grow to 65% by 2030. This new flow of capital could mean that while London and Paris continue to score high on the key principles needed for a successful arbitration hub, if the parties to a contract are from Asia or the Middle East, they might look closer to home for a trusted seat rather than Europe. No city, therefore, can rest on its laurels or assume they will continue to be a preferred seat as the global economy and commerce evolves. With this landscape and background in mind, how can a city go from a wannabe to where to be? So I see real opportunity for a city, or even cities in Africa or Latin America, to rise as a preferred neutral hub for intra-regional disputes. Regional trade is increasing in Africa following the ratification of the African Continental Free Trade Agreement, which is expected to boost intra-African trade by 53% this year. A city in Africa could become the go-to place for arbitration involving all African parties, even when none of the parties are from that jurisdiction. The same is true for a city in Latin America, given that there is no city in the region today that stands out as a seat for intra-regional disputes. Of course, we see arbitration seated in Latin America, but in almost all circumstances, those cases involve a party or all parties from that jurisdiction. Parties in a few cases have selected Santiago, Chile as a seat, even though the cases don't involve any parties from Chile. So one question on my mind is whether parties will continue to select New York or Miami or cities in Europe, such as Paris, Madrid, or London, in cases concerning intra-regional disputes in Latin America. I also see an opportunity for civil law jurisdictions in Asia and elsewhere. Singapore is the clear preferred seat for Asia-related disputes. But will there be other jurisdictions, particularly a civil law jurisdiction, that can promote itself as a viable alternative? The city would require a long-term, comprehensive strategy around its courts to make the benefit readily apparent. More generally, we know there is a close relationship between the selection of a seat and the selection of the applicable governing law. Singapore law has consistently been the dominant choice for governing law in SIAC in Singapore. English law accounts for approximately 80% of cases at the LCIA. Hong Kong law has consistently remained the most popular law in HKIC. And Dubai and UAE laws have historically been the most frequently selected at DIAC. At the ICC court, last year, the seat and governing law matched in 56% of the cases. Is there any civil law, French, Spanish, German, Swiss, that would become more frequently adopted as a neutral law, especially when all of the parties come from a civil law jurisdiction? Are parties choosing English law, New York law, and increasingly Singapore law because the lawyers handling the transaction are from those jurisdictions? Are parties choosing those laws because the lawyers handling the transaction received law degrees such as LLMs from those jurisdictions and were admitted to the New York bar or as an English solicitor? And are those laws viewed as favorable or merely familiar? Many questions indeed, which I think would make great PhD research topics. And in the same way that LLM programs in the United States have enabled lawyers to take the New York bar, it may be that the master's programs in other jurisdictions could be an important element to the promotion of the governing law. The UK definitely understands the importance to the economy of English law in international contracts that have nothing to do with the United Kingdom. The Minister of Justice actively promotes English law around the world. Other jurisdictions may wish to engage in similar promotion of its governing laws. As in any competitive field, success depends in part on your unique selling points. It may be global reach or the extent of local knowledge, a particular expertise, or a sterling reputation for client service. However, trying to replicate what other long-standing hubs have to offer, rather than considering the jurisdiction's unique selling points, is a likely recipe for failure. To be sure, consider the best practices of other successful jurisdictions, but also develop and promote your unique strengths. One example in this regard is China. The Chinese are addressing some of the country's challenges of becoming a hub by implementing a verification mechanism that requires the Supreme People's Court to make a final decision on any proposition of non-enforcement by a lower court. And even if the formalities of the legal ecosystem are in line with international standards, think about what are the procedural hurdles in your jurisdiction. Are there ways to minimize delay in multiple layers of appeals, not only for setting aside proceedings, but also for interim relief? What mechanism should be adopted to create more certainty and predictability? A jurisdiction such as India, and especially Delhi, have come a long way over the last few years to become an arbitration-friendly seat. But some decisions that were not in line with international standards cause even the most ardent supporters of India to suggest Singapore as a seat instead. Specialized commercial courts with specific jurisdiction over international arbitration challenges can be established. It can also facilitate sharing best practices, cross-border training, and education on arbitration for counsel and judges within the specialized court system. How this works is key. In Delhi, for example, there are commercial courts, but they have a roster system in which a judge sits on an arbitration court for no more than 6 months, adding to the uncertainty. If language is a barrier, will the jurisdiction allow the use of English in the courts? This approach has been adopted in a variety of jurisdictions, such as Japan. Ideally, though, there needs to be a sufficient number of judges who can conduct such proceedings in English. Also essential is the ease of access to the jurisdiction for everyone involved in the proceedings, including support staff. A city's success can turn on whether it has reliable and safe transportation links and visa and tax regulations favorable to parties, counsel, and arbitrators. To all cities looking to become a preferred seat in international arbitration, I highly recommend being realistic about your goals and recalibrating if necessary. They may want to promote domestic arbitration, not as a stepping stone to global prominence, but as an alternative to courts, especially if the courts are backlogged. But to become a preferred seat, a city should focus on its unique strengths. Beyond a sound legal infrastructure, they must address procedural hurdles and uncertainty to ensure that parties have confidence and trust in the court system. And they must create a vibrant and business-friendly environment in the city that's conducive to resolving arbitration disputes. Equally important, arbitral seats can only succeed where strengthening the arbitration ecosystem occurs simultaneously with making a genuine commitment to the rule of law. And don't forget, a little marketing and self-promotion of your city as an arbitration hub goes a long way. Thank you, Charles Brower, Melida Hodson, and the American Society for International Law. Thank you to Georgetown Law School, and I'm happy to answer any questions. Stay here. Oh, I see hands.
Thank you so much, Claudia, for those great remarks, insightful remarks about how to go from wannabe to where to be. Well, we've got Lucinda ready with a question already.
And I've got the microphone. Thank you, Claudia. Having just come from Paris Arbitration Week, as you know, I can't help but ask a question about Paris as a seat, because I did hear some commentary from people that the more activist, shall we say, posture of certain French courts was discouraging the use of Paris as a seat. Do you want to comment on that?
Yeah. Well, I'm not a French lawyer, so I won't comment specifically on any individual decisions, but it is really the arbitration-friendly and arbitration-supportive nature of French courts historically that has been an essential aspect of Paris as a preferred neutral hub for many, many years. There have been some decisions in recent years that have definitely caused people pause, and that's really part of the effort right now to potentially amend the arbitration law to address some of those issues.
Hi, I'm Charles Camp here in Washington. You didn't mention Stockholm at all. What are your thoughts on Stockholm? I'd love to hear that. Thank you.
I mean, Stockholm historically was the preferred seat for East-West disputes, and it is still a prominent seat for many seats related to Central and Eastern Europe. I don't see it listed among the top 5, but certainly Stockholm is regularly selected. I don't have a specific view. I think it's one of those cities that falls within the safe seat category and definitely would be viewed as having all of the, would check all the boxes. And then I think the question is then why, and I don't have an answer, why it has diminished in favor compared to other cities.
I had great success there.
Yes.
For developing and post-conflict countries that are looking to develop their arbitration industry, do the local Chamber of Commerces have a role in promoting that?
What we know is there are so many different types of chambers of commerce. Even my notion of a chamber of commerce from a US perspective has been shattered as I've learned that even in some countries like Spain, businesses are required to be members of chambers of commerce, and other jurisdictions, the chambers of commerce are actually run by the government, so they're not necessarily distinct voice. So many varieties, but in terms of organizations that businesses trust and organizations that are sources of information, I think that's the thing. Chambers of commerce have historically been places where particularly small businesses have gotten essential information and tools that they might not have otherwise gotten in our modern era of obtaining information through electronic means, that they do become a trusted source of information. And what we know is, small and medium-sized enterprises really drive the global economy. And so, especially from the ICC perspective, we are particularly focused on communicating the value of arbitration as an avenue of recourse, as an important tool for managing risk for small and medium-sized companies. Other questions? Comments? Yes?
I think I can give you an answer with respect to
to-
Sweden, which is a member state of the European Union. Sweden always had a problem with the, let's say, a court of appeal acting like an original arbitration and not respecting very much what they've done. I've had personal experience with that. What has happened is that people don't want to go to Sweden anymore because the courts will apply the European law, which says you can't be here before we have to apply this. So the Swedish Chamber of Commerce Arbitration Institute very recently announced that it would no longer specify or appoint Sweden as or any other member, I think, of the European Union as the place of arbitration, unless the parties agree, and I can't imagine why they would. So they are essentially going out of business in the international business because they know they can't appoint Sweden as a place. It's a very important self-denunciation by that institute of it's what it will do.
Anyone else?
Polite note, you had mentioned the attraction to arbitrators of the charms, the meals, the restaurants, the hotels in London, in Paris, and some of these other places. But you're right about Singapore. It is, I like it very much. I have been there a number of times. I describe it as a pretty much a democracy, but with a lot of central direction from the government and long planning. There are certain things you can get done, certain things you cannot get done. But they've had their eye on this for a long time, and they have lots of advantages, even if the restaurants.
Yeah. Terrific. I see a hand in the back. Mark.
My name is Mark Goldstein from New York. Once, many, many years ago, I was involved in the case where the seat of the arbitration chosen in the contract juridically was no longer there, if you will. And we had an instance where the ICC court was charged with deciding what the seat should be. I wonder if you've had any exposure to the issue of, for whatever reasons, there not being a chosen seat, and how the ICC court approaches resolving that issue when there is a gap in choice.
Yeah. So under the ICC rules, if the parties have not chosen a seat, then it is the ICC court which makes the selection. I've been looking at that issue in particular because it's different under the ICC rules than the selection of the language of arbitration, which is under the current rules, the choice of the tribunal. But other institutions do have the tribunal decide the seat, which is in some ways surprising to me because deciding whether you have jurisdiction over a particular matter may depend on which seat. So it's interesting that for institutions that have structure, they nonetheless allow the tribunal to decide. I mean, it would be the case in an ad hoc arbitration that the tribunal would make such a decision. So we are also examining whether the tribunal should be deciding language, even though the court decides the seat. So how do we go about that? We'll obviously take into account parties' views, but most significantly, when we're making a decision, we are looking to select a neutral seat, so not the seat of any one party, and without likely benefit of one party to the other. So then we're also looking at geography among the most traditional seats. I know some parties have assumed we're always picking Paris as a default, and that is not the case in ICC arbitration. Whereas other institutions do have their own cities where they're from as their default if the parties have not chosen. So, yeah.
Great, thank you so much. Thank you for your talk. We've seen a huge uptick in the last 5 years or so in the area of mediation. To what extent, and I understand, of course, the difference between mediation and arbitration, but we're starting to see some mediation as in aid of arbitration or arbitration aid of mediation, vice versa. To what extent do you think that a city's capacity in the mediation space will become an important factor? And if it is a factor already, again, I know, we know Singapore has been at the forefront of that. Is that, do you think, also part of this effort to deliberately see itself as a dispute resolution hub?
Yeah. I mean, what we know is companies and states, parties in a dispute want all the tools in their toolbox available to reach a resolution. And so for cities that are really trying to promote themselves, not just as an arbitration hub, but that in essence, the legal ecosystem is driving their economy or a key driver of the economy, they understand that having legal professionals involved in dispute resolution of all types is essential. So having strong and quality arbitrators, having arbitration practitioners, like an arbitration bar, is important, and then also having mediators. I mean, jurisdiction like India recognizes that it's very important to have specialty lawyers, you know, an arbitration bar, if they're really going to become a neutral hub, but also foster the domestic arbitration culture, which they're trying to do as well. Anyone else? Yeah.
Thank you. Thank you, Claudia. Michael Cooper with ASIL. You had mentioned that a Japanese colleague determined that Japan had failed because they had been at it for a whole 2 years and hadn't really seen enough action. And you really emphasized the importance of a long-term commitment. But could you speak more to the metrics of that? How long should a city try? Should they have a 7-year plan, a 10-year plan? And when do they know that they've either succeeded or failed? If you have 3% of the market after 7 years, can you say you're successful and you keep going? Yeah. Could you just talk about what success looks like and what failure looks like?
Yeah. We have really been digging into this issue because some arbitral institutions shortly after COVID were talking about how their numbers were up or down because of COVID-related disputes. And from our perspective, we have, as I described, a much longer lag between when a contract is signed. And so in arbitral institutions where most of the disputes are relatively small, like in sales contracts, like if I sell you this water and you don't pay, we immediately have a dispute. So disputes arise very quickly in sales contracts. But if you are involved in a major infrastructure project or a development or cooperation agreement in the life sciences space, those kinds of agreements are long-term relationships, and disputes take a long time. And then also statutes of limitation impact that as well. So the lag between when a contract is signed and when a dispute percolates really depends on the type of contracts you're trying to attract. So if you're trying to think about a hearing center, for example, it would be, and what is your short-term, medium-term, and long-term planning? You should also be thinking about what kind of disputes are you likely to have at that hearing center. If it's basic sales disputes, likely for, let's say, small and medium-sized enterprises who need to pursue a claim right away in order to assure the flow of capital, then the lag will be much quicker. If you're looking for the mega dispute arising from infrastructure projects, construction, energy, life sciences, those are going to have a much longer tail and often have mechanisms in which the parties themselves need to go through alternative dispute resolution procedures before they would even file. And also, I mean, the global economy will definitely shape the number of disputes that get filed and how parties are thinking about that. That's something that Merritt Krasula, who's here, the regional director for ICC in North America, and I were discussing. Does current events likely lead to more disputes? In an earlier era, we always talked about disputes as being counter-cyclical to transactional work, but in this era, it's more likely that disputes actually flow from the the number of deals really result in more disputes. And if there's too much risk, there may be less disputes. So kind of how to think long-term or medium-term, but maybe all that to be said, I think anyone needs to be thinking in 5 to 10-year horizons at the shortest. Because if I convince you today to use ICC arbitration, one, you might never have a dispute, but two, it's likely to be in a 50% chance 5 to 10 years from now that any dispute would even arise. Yes, John. My predecessor's predecessor, for whom the statistics of 2025 are likely the result of his effort.
It wouldn't be an ICC presentation without statistics, Claudia. As part of this process of working out what the best policy might be for a particular institution, do you, as a matter of policy, take surveys of your users? And if you do you publish them?
We have actually just undergone a major survey conducted by EY, and those looking at their preferences, and those results we are expecting to both provide us with key information and for that information to be made public. So I think that's going to be we're trying to understand parties' preferences and parties' long-term perspectives. From my perspective now, I have kind of tried to use the data to tell a story. Like, what can we better understand about the parties? And it tells a story, but it's backward looking. Any data currently is about the kinds of agreements that were entered into in the past. And so if we're trying to understand what kind of disputes are going to arise in the future and how parties are going to be thinking about those, we need to understand what kind of deal flow is happening. We need to follow the money now to know what will be in the future. Anyone else? Okay.
Thank you so much.
All right, thank you.